Hello, I'm Jessica Ryan Keeney. I am the Lassen County Department of Child Support Services attorney. I'm licensed to practice law in the state of California only. This video applies to California only. I've been practicing family law since December of 2009 when I was sworn into the California bar. Before that, I worked as a law student for family law attorney starting at the end of my second year of law school. It was a 4-year program. And I'm a former city attorney for a small rural Northern California city. I did that for about 5 years. What I'm about to say today is not legal advice. This is for educational purposes only. Go ahead, like the video, ding the bell, subscribe, make sure that you get notifications when we upload future content. Once again, my son's in the office with me today, so you might hear him say something or be playing in the background. You also might see him make a cameo or two. Not a whole lot I can do about that. Enjoy the appearance if he makes one, and thank you for your patience. So today's video discusses how the court handles imputing income when a parent voluntarily quits work or decreases their income. And unlike the past few imputing income videos where I actually briefed all of the cases, I'm not going to do that in this one because most of the cases I'm going to talk about I've briefed in a previous video, plus those videos were long and boring. So we're going to start with the family code. That's Family Code Section 4058, which this is going to be a long and boring part. It says the court may, in its discretion, consider the earning capacity of a parent in lieu of the parent's income, consistent with the best interests of the children, taking into consideration the overall welfare and developmental needs of the children and the time the parent spends with the children. When determining the earning capacity of the parent pursuant to this subdivision, the court shall consider the specific circumstances of the parent to the extent known. Those circumstances include but are not limited to the parent's assets, residence, employment and earnings history, job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers, and record of seeking work, as well as the local job market, the availability of employers willing to hire the parent, prevailing earnings levels in the local community, and other relevant background factors affecting the parent's ability to earn. The standard rules of imputing income apply, okay? And those are as follows. Imputed income must be based on the earnings capacity of the parent. Okay, I'll say rules are slightly different when a parent intentionally quits working to avoid child support or commits misconduct to avoid child support. We'll get to that at the end. Okay, but except for those circumstances, these normal rules apply. Imputed income must be based on the earning capacity of the parent. Earning capacity is composed of the ability and opportunity to earn an income, and that's Family Code Section 4058, which we just read. That one's the one that doesn't apply to intentional misconduct or intentionally quitting or decreasing income to avoid paying child support. Okay, but the rest of these will apply to all of the circumstances. Imputing income must be in the best interest of the children support is being paid for, and this is in remarriage of Hinman. The party asking that income be imputed has the burden of proving imputee has the ability and opportunity to earn the imputed income. Okay, this one doesn't apply to misconduct or conduct in an attempt to avoid paying child support. It applies to everything else though. And this is in remarriage of Wittgrove, in remarriage of Bardzik. The court need not find that a parent acted in bad faith, was trying to avoid paying child support, to impute income to that parent. In early cases, there was a requirement that a parent had to act in bad faith before the court could impute income. And then around the time of Hinman and a few years before, the court started saying, no, we don't have to find that there was, that the parent was acting in bad faith to impute income. But it seemed like the message hadn't quite sunk in and people kept making that argument. So in remarriage of Lassen or Ilas, and in remarriage of Padilla, and in remarriage of Hinman stand for that proposition. And Lassen and Padilla came before Hinman, And in Lassen and Padilla, the court said, no, we don't have to find, or the trial court doesn't have to find that the parent was acting in bad faith before income can be imputed. And then in remarriage of Hinman, the court was like, dude, we're going to make it really, really clear. There need not be a finding of bad faith before income can be imputed. And then let's see, the parent asking that income be imputed has the burden of proving that imputing income is in the best interest of the children. And this applies regardless of if the imputee is the custodial or the non-custodial parent. And the imputee is the person, the parent, that income is being imputed to. And this is in remarriage of Mosley. Of course, there are other cases that say this too. That's just the one that I briefed when prepping for this. Imputing income to a parent, even the non-custodial parent, must be in the best interests of the children. Again, this is in remarriage of Mosley, in remarriage of Sheridan, in remarriage of Lim and Carrasco. And my observation from the case law is that it's easier to prove that it's in the best interest of the children to impute income to the non-custodial parent than it is to the custodial parent. However, my observation from actually appearing in court in the counties I appear in is that the court is equally inclined to impute income to the custodial parent and the non-custodial parent. When income is imputed to the custodial parent, the court must find that imputing income is in the best interest of the children. That's in remarriage of Labass and Muncie. And the court must make express findings supported by substantial evidence that imputing income to the custodial parent is in the best interest of the children. And that's in remarriage of Fick. And so I haven't given you the entire citation of all of these cases. The whole citation to all of these cases will be in the description below so that you can go read the cases on your own. When a parent voluntarily quits working or decreases their income, they're not trying to avoid child support. The court may set child support based on the parent's ability and opportunity to earn, aka their earning capacity. And this is in remarriage of Paulin and marriage of Berger. And when a parent voluntarily defers his or her salary instead of taking it as income, the court may consider the salary being deferred to be the actual income for purposes of calculating child support. And again, this is in remarriage of Berger. This next bit is a quote from the California Court of Appeal. When child support is ordered at a time when both parents are employed and thereafter one arbitrarily decides to stop working, perhaps because of remarriage to somebody with significant income, the court must possess the discretion to consider the parent's earning capacity in ordering child support. Otherwise, one parent, by a unilateral decision, could eliminate his or her responsibility to contribute to the support of the child, causing the entire burden of supporting the child to fall upon the other parent. And that's in remarriage of Paulin. When a parent voluntarily stops working to care for a preschool-age child, so long as the parent's not receiving cash aid, public assistance, or CalWorks, there is no per se rule that the court may not impute income to that parent. Instead, the trial court has discretion to consider the earning capacity, that's the ability and opportunity to earn, of the parent in deciding if income should be imputed to that parent. That's in remarriage of Hinman. A parent may voluntarily quit working excessive overtime and work a reasonable work schedule, so long as the parent's not trying to avoid paying child support. If the court is going to impute income in this situation, it must be based on a reasonable work regime and not excessive overtime. Actually, that's in any situation. And the court's clear that a reasonable work regime is based on the circumstances surrounding the job, what's normal in the field. However, there are some fields like the practice of law where somebody's working for a big firm where they're expected to bill 2,500 hours a year, and that requires them to work 60 to 80 hours a week or more in order to bill that many hours. And the court's clear that that's not a reasonable work schedule. And so there's one case where the court determined that working 60 hours a week wasn't a reasonable work schedule. And then the case of the lawyer at the big firm, the court determined that working 80 hours a week wasn't a reasonable work schedule. So you got to look at the totality of the circumstances. Anyway, this is in remarriage of Simpson and in remarriage of Lim and Carrasco. When a parent quits working because he or she received an inheritance, reasonable rental income may be imputed to the rental property that was inherited, and the amount that the inheritance reduced the living expenses of that parent may be considered income for purposes of calculating child support. This is County of Kern v. Castle, and it's pretty common in a situation like this to see a parent suddenly living in a mortgage-free home. Maybe they use the inheritance to pay off the mortgage on their house, or maybe they sell their house or turn it into a rental and then go live in a house that's owned outright so they don't have a mortgage. So in this situation, the amount that the inheritance decreased their living expense. So in the example of a mortgage-free home, the amount of mortgage expense that that parent no longer has may be considered income for calculating child support. So let's say that the mortgage was running the parent $2,000 a month, and after receiving the inheritance, the parent no longer has that $2,000 a month mortgage payment. That $2,000 a month can be considered income to that parent. When a parent quits working to retire early, the parent wanting income to be imputed still has the burden of proving that the imputee has the ability and opportunity to earn the income to be imputed. This is in remarriage of Bardzik. When a parent commits misconduct that causes him or her to lose his or her job, but the parent wasn't trying to avoid paying child support, in order to impute income to that parent, the court must still find that the parent had the ability and opportunity to earn the income being imputed. This is in remarriage of Eggers. When a parent voluntarily quits working or decreases their income, this time to avoid paying child support, the court may impute income based on the previous earnings of the parent, even without evidence that the parent can actually earn that income that's being imputed. And an example of this is when a parent commits misconduct at work to avoid paying child support, and that misconduct gets the parent fired. And this is McHugh v. McHugh. So ways to show ability and an opportunity to earn, or the earning capacity of the parent, are things like present the resume of the imputee, have the imputee take the stand and testify about his or her job skills and education. If you're married to the imputee, probably, and the imputee, say, doesn't show up at court for the hearing, that does happen, then you probably know enough about the imputee to testify yourself about their job skills, education, and abilities. Have a vocational evaluation done on the imputee and have the vocational evaluator testify about the job skills and education of the imputee, as well as the job market for people with the skills and education of the imputee. Present job postings and want ads. Want ads are an old school thing for jobs looking for people with the skills and education of the imputee. And there's actually case law that says that those job postings and want ads are not hearsay, but they are being offered to show that opportunities to bargain exist, or something to that effect. And present pay scales for jobs requiring the skills and abilities of the imputee. So this requires a little bit of sophistication, because you need to be able to present evidence, attach exhibits to your motion, and admit things into evidence. But there you go. There's a list of things that can be helpful in imputing income. And these are things discussed in marriage of Bardzik, in remarriage of Lassen and Muncie, and in remarriage of Hinman. So there you have it. Imputing income to a parent who voluntarily quits work or decreases their income, or a parent who commits misconduct, either trying to avoid paying child support or not trying to avoid paying child support, and that causes them to lose their job or suffer a decrease in income. And this was not legal advice. Always be sure to seek the advice of an attorney to make sure that the laws that you're going to try to apply to your case actually apply to your case, and to make sure that you understand the law that you're reading. If you have any questions, comments, or concerns, put them in the comments below. If we answer, it won't be legal advice. It'll be for educational purposes only. Those questions, comments, and concerns often make for good video topics in the future. Thank you for staying tuned through this entire video. Please be sure to give it a like and subscribe, ding the bell so that you get notifications when we upload future content. We look forward to seeing you next time. Thank you.